Hi, I'm John Counsel. I'm a senior reporter with Texas Lawyer newspaper, and welcome to the October 3rd, 2008 edition of Reversed and Remanded. My guest today is Marty Rose. Marty is a partner in Rose Walker here in Dallas, and Marty, just hot off the presses, just prevailed in a very interesting case in Collin County. This is a fee dispute case between his client, which is McAfee, basically, Plano, and Wilmer Hale, which is a very storied and large law firm on the East Coast. Boston is based. Right. And as I understand it, Marty, this case was before Judge Mark Rush in district court, and was it a motion to dismiss this fee dispute?
Correct.
And it survived.
Yes, it did. By way of a brief recap, we had filed in state court in Collin County in Judge Rush's court. It was removed by Wilmer Hale to Eastern District of Texas, Tyler Division, and Judge Schneider in that division decided he did not have subject matter jurisdiction, and so we remanded it back to the state court. The theory has been, and the dispute has been, whether McAfee, who's been paying the legal fees for a criminal defense of one of its former CFO,
correct,
a man named Mr. Goyle, pursuant to an indemnity agreement they had with him as part of his employment agreement,
right,
whether they had to wait and litigate reasonable and necessary issues about the legal fees in Delaware Chancery Court as the agreement provides as part of the forum selection clause, or they could bring an action here in Texas where the bills were presented and paid under Texas law. We alleged both, of course, reasonable and unnecessary, but primary focus has always been that it was fraudulent billing. We were overbilled. Right.
So, Judge, they had asked Judge Rush to dismiss all of your causes of action, and he dismissed seveul of them, didn't he? Except for one.
Yes, he did. Yeah. He agreed. He agreed with analysis of Judge Schneider in Tyler that the negligence cause of action and the breach of fiduciary duty cause of action were completely tied to the underlying indemnity contract between McAfee and Goyle. In essence, you could think of Wilmer Hale as being an unintended third-party beneficiary of that contract.
Right.
And under that contract and under Delaware Chancery rules, issues about the reasonableness and necessity of the fees await the final outcome of the underlying criminal litigation and then a lawsuit in Delaware Chancery Court. So that was the theory, and he agreed that as to the negligence claims, they arose under that indemnity contract, but as to the tort claim of fraud, why that survives here in Texas and is going to go forward and be litigated in Texas.
Right. So your allegations is that they overbilled. I think the legal bill is somewhere in the range of $12 million to defend in this. It's an SEC action. No, it's a securities fraud action the DOJ brought, which is still not completed. He has been convicted, but hasn't been sentenced.
Right. He was sentenced yesterday.
Oh, he was.
Oh, okay. And I double checked this morning. He was sentenced to a year in prison and a fine of, I think, $250,000.
Right. So if I'm Wilmer Hale, what I'm going to say to you is, look, this is attorney-client privilege. We haven't waived anything. My client hasn't waived anything. You can't do discovery on this case because this is between me and my client. You just got to pay the law bill. Sorry.
That's exactly what they said.
Okay.
And that's exactly their attitude. And our response, and Judge Rush's response, interestingly, is twofold. One, if you defrauded us, then it's not between ourselves and Mr. Goyle and the indemnity contract. It's between us and you because you defrauded us. Number one. Number two, you know, as His Honor said in court yesterday, you know, we here in Texas have privilege logs. We have confidentiality agreements. We have all kinds of effective tools to protect privileged and confidential and private communications, and we can do so. Our view is even a bit more simplistic than that. We allege and we believe we can prove that they actually billed us for work that was never performed. I don't know how the privilege issue would ever really arise if a lawyer didn't actually do the work that they claimed they did. there really isn't a privilege issue to look at.
But in WilmerHale's defense, they're going to say this is a massive case. There's 1.2 million documents to look over. This is expensive, but we'll show you what we got. And I guess that's what we're going to see in upcoming months in this case.
Well, in fact, they've attracted even more pointedly, pointing to other similar white-collar criminal cases. The Enron case with Jeffrey Skilling, a lot of the cases are going on right now in in Northern California in particular, where there are white-collar criminal acts being alleged and enormous sums being spent in defense. What is unique about this case, in the first place, is there was no parallel civil litigation. So this was a one-defendant criminal case. He was convicted on all counts, by the way, 15 counts, with no ancillary civil litigation. So the cost just shouldn't have been there. And secondly, you know, it's like the old saw, because I see somebody run a red light, it's okay for me to run a red light. I don't think that's the law. So that's what we're going to find out. Well,
I guess, and that will be Collin, WilmerHale's lawyers pretty soon, and I'll get their side of the story, and it's going to be one heck of a story in Texas Lawyer. All right. You know what? I'm going to cut right to what I like to call the witness stand, and I'm going to put Marty through some completely ridiculous questions. And this week, we're going to have the Sarah Palin Memorial witness stand, where I'm going to ask the very same questions the media did to Sarah Palin. Okay, Marty, question number 1. Name a Supreme Court decision you disagree with besides Roe v. Wade. Not that you disagree with it. I don't know.
I don't disagree with Roe v. Wade.
Anyone.
Anyone.
Name anyone.
Just off the
top of your head.
Let's see what I disagree with. I disagree with the recent decision regarding product liability. The decision that said that if the government approved a product as part of a regulatory scheme,
okay,
it shifts the burden of proof.
You know the name of that case?
Of course not.
Sarah Palin would
I'm just a lawyer.
Okay, just a lawyer. All right. What is the Bush Doctrine?
Bush Doctrine is the idea that we can be an aggressor against the country who's not been an aggressor against us.
Peremptory strike.
Yes.
Very good. Okay.
So I could be vice president.
You could. Can you see a foreign country from your front yard, and how does that affect your ability to mine and distribute and lead our country through foreign policy problems?
I cannot see a country through. Well, I'm not close enough to Mexico, so I can't.
No, not even with binoculars.
No,
okay.
No.
Final question. What newspapers do you read? Any of them?
New York Times, Dallas Morning News, occasionally Wall Street Journal, just for comedic effect.
You better read this one, or I'm kicking you off my video blog. All right.
Multiple subscriptions to Texas Lawyer, and you can check your subscription rules.
Thanks, Marty.